All right, well, I guess we could go ahead and get started. Morning, I'm Dane Ciolino. I am a 1988 law grad from Tulane. And what is this? Is alumni weekend or homecoming weekend? Is that what it is? Is that what this is all about? Yeah, I'm currently a professor at Loyola University, New Orleans Law School, where I teach, among other things, legal ethics, and that's why I'm here today to talk about what the slide says: recent developments in legal ethics. This is kind of nothing other than things that have happened in the last year or two that I think are either interesting to those of us in legal ethics or important for lawyers to know. Some of what I'm going to talk about is Louisiana oriented, but not all of it or much of it. So if you're not from Louisiana and I start talking about something from Louisiana, don't feel like you're going to hear that for the whole hour. You're not. Also, there are only 6 or 7 of us here, so feel free to interrupt me. And if you want to talk about something else, or you disagree with something I say, or you think something that you see on the slide is ridiculous, not that I had anything to do with it, let's talk about it, because there's only 6 or 7 of us here. All right, so this thing doesn't seem to be working. Is it? No. Well, I don't know. Since the Zoom, there we go. Oh, that seems to work, but this should work. That seems to work. Yeah, good. Okay, first of all, some developments in rulemaking. This is one of the Louisiana cases or developments that I do want to talk about, because Louisiana's got the most ridiculous advertising regulations in the country. And it's just because members of the legislature drive between New Orleans and Baton Rouge. And I don't know if any of you have done it recently, but there's nothing but lawyer billboards between here and Baton Rouge, and all the way to Lafayette, and probably all the way to Lake Charles. The legislature hates it. So the legislature has passed, and the governor has signed, some legislation purporting to regulate lawyer advertising, but they've also just harangued the Louisiana Supreme Court to do something about this lawyer advertising. And so they have done something about it, kind of consistent with that silly syllogism, which is, something must be done. This is something, so this must be done. And that's this is the most recent effort to do something, which is to require lawyers to pre-submit their ads, and they've had to do that for about 10 years, maybe more now, 10 or 11 years. Lawyers have to pre-submit their ads. Now you have to get a ID number for your ad to put on the ad. So that way, when the LSBA is driving around taking pictures of billboards, and they do that, then they can see right from the face of the billboard whether you have pre-submitted it, because you'll have tattooed on your ad the little number that the LSBA has given to it. And that is the kind of the most recent thing that they have done. Also, you're going to have to put kind of break down settlement amounts. You can't just say, my lawyer got me $300,000. You have to say that some portion of it included fees to the lawyers and that sort of stuff. Again, the thinking is this is going to make things better. We've been regulating lawyer advertising since 2008 very strictly, and I don't think things have gotten better or whatever that is. But for me, I mean, it doesn't really bother me, these ads. I just avert my eyes. I don't. You can put whatever you want on a billboard. I'll just keep driving, and that's what I do. But some people don't like it. Some of this may be subject to First Amendment challenges. Back in 2010, I represented some lawyers who sued the bar because of unconstitutional First Amendment problems related to the original set of regulations, and we won in the Fifth Circuit. The bar had to pay a lot of money in attorney fees that was wasted, stupid regulations. This to me strikes me as maybe a little bit of a prior restraint, because your government is telling you that you cannot speak until you get their number that you can put on your speech and deliver the number, the stamp of approval. That to me is wrong, and I hope somebody wants to challenge it because I'm ready to go. We'll see. This is something that just came down a couple of weeks ago, a couple of months ago. That was interesting to me is that trade names. You see lawyer trade names like Lemon Law Clinic or Divorce Law Clinic or something like that. Some states have been very restrictive of lawyers being able to do that. New York most recently just said now it's okay as long as it's not false or misleading. Louisiana, of course, can't help itself. It regulates in this area too. It allows trade names, but it says that you cannot use more than one trade name. You know, it seems a little arbitrary, but that's the rule. You can't, for example, have a law office where you have the Lemon Law Clinic, the Divorce Law Clinic. You got to pick one trade name and use the one trade name in Louisiana. But again, kind of odd. All right, a couple of recent opinions. Those of us in legal ethics are always following what the ABA Committee on Professional Responsibility does. They put out 6 or 7 new opinions every year. Some of them are interesting, some of them are not helpful at all, but it's always interesting or important to us when they come out. And here's one that came out last year that addresses the issue of what happens if you have a case against a friend of yours. What happens if you have a case against your spouse who's a lawyer? What happens if you have a case against someone who's your good friend from law school? Does that present a personal interest conflict? Now, of course, under Rule 1.7A2, lawyers have a conflict of interest. If there's some significant risk that their representation of a client would be limited by a personal relationship. So I think we would all agree that if you are opposite to your spouse in a case, then that would present a personal interest conflict, and you're really going to file sanction motions against him or her because of something that he or she did during litigation. Doubtful. That's something that the ABA said is clearly a personal interest conflict, possibly waivable, but clearly a conflict. But as to the other 2 categories identified by the ABA, a mere acquaintance, somebody you know from the courthouse or maybe the ball field where your kids play Little League, that doesn't even raise any real issues. But close friends, that's the gray area. And can you be adverse to your close friend in a case as a lawyer? I mean, I know I have been in my practice, and I think most lawyers are pretty good at understanding what hats they're wearing at various different times. But the ABA said that's something you need to disclose to your client. Waivable, but it's something that needs to be disclosed and discussed, which I thought was kind of interesting. Now, this is a question that I got a couple of times from clients just this year, so I decided to turn it into a slide. And what's the issue? Suppose that you are an estate planning lawyer and you want to send your clients to a financial planner who is going to talk to them about the tax consequences of an estate plan, maybe set them up with life insurance, maybe set them up with a brokerage account and those sorts of things. Can you do that? Can you have a guy that you work with, and then maybe that guy sends you some money for sending along a client? And that's the question. Well, the short answer is yes, that's okay as long as the client understands what you're doing and it's a non-exclusive referral agreement. There is a personal interest conflict there. I've been talking personal interest conflicts because you, the lawyer, have a personal interest in referring your clients to this financial advisor, not that financial advisor, because you want the fee that you're going to get pursuant to your non-exclusive referral agreement. Again, waivable, you just disclose that to the client and it's going to be okay. Now, the problem, and this is in the ABA rules, it's got to be non-exclusive because it would impair your professional judgment if you were limited contractually to sending everybody to that lawyer or that advisor rather than this one or that. And you can't limit your professional judgment like that. So as long as it's non-exclusive, as long as it's disclosed and confirmed in writing, and waived by the client, no problem there. Now, this is a formal opinion that the ABA came out with this year for obvious reasons. We all, back in March 2020, started working remotely, and lawyers were curious about what sorts of things, what sort of ethical problems they would have with remote work. And by remote work, of course, remote work is going to require cloud storage of documents, use of Zoom, and lots more email and chat and threaded communications, those sorts of things. So that's what the ABA attempted to address. Now, for those of us, and us, I mean me, who are kind of very technologically proficient and dependent, even before the pandemic, this kind of taught me nothing. But for lawyers who were more challenged, maybe it's useful. But again, mostly focused on what reasonable measures lawyers need to do to preserve the confidentiality of their clients' information, and that really is the main part of it. The one thing that was mentioned in here is on Wi-Fi networks, whether or not when you are at a remote location, you should be using some sort of encryption or some sort of VPN, virtual private network. And, you know, I've always been of the view, well, first of all, the ABA rules, Rule 1.6c, only says that you've got to undertake reasonable measures to protect confidentiality. That's a relatively recent amendment that I like, because so many lawyers raised the boogeyman of confidentiality. I can't do that. It's not confidential. But 1.6c says only reasonable measures. You don't have to take uber security measures, reasonable measures. And that means you don't have to do things like encrypted email. In fact, I got an encrypted email yesterday from a neuropsychologist for one of my clients doing a cognitive evaluation. And it just made me angry to get the encrypted email. Yeah, question.
Yeah, question is, you know, this is an interesting topic, right? Because of all of the ransomware attacks, things like that. And when you think of the, you know, the information that you could get here could be worth something. And I think there have been some ransomware attacks already. So is there any reference to, it sounds like from what you're saying, we've been talking, not that you don't need to encrypt email, there probably isn't. But I guess any reputable firm is going to be taking some pretty robust steps to protect from ransomware attacks.
Yeah, and most of the ransomware attacks start as phishing, when you get that email and say, click here, and those sorts of things. And this opinion does speak to that and tell lawyers, basically, don't be an idiot. You know, don't just see that bright purple worm and bite on it, because it's probably not going to be very tasty. And I don't know what to say about that so many people do click on those things. And I think I got hit with it once, but yeah, I don't know what more to say about it other than don't do that. I'm trying to remember if they said much else about those sorts of things. No, they really didn't. But that's obviously a big concern. We always, probably once a month, I'm getting emails from somebody I know it's a hacked email. This is something that actually came up this summer with one of my clients. And it's kind of related to what we just talked about. This is the issue of whether or not it's appropriate for one lawyer to listen in surreptitiously to another lawyer giving advice to her client. And this is what happened. At a big law firm downtown New Orleans, in a conference room, the lawyers, a bunch of lawyers were there because it was a deposition. It was a live deposition, but some lawyers were participating by Zoom. So they're doing the deposition by Zoom, and then they take a break at mid-morning. And during the break, my client, a lawyer, and his client, a non-lawyer, who was being deposed, started talking. Everybody's out of the room. They just start talking. Well, what they didn't know is that the Zoom link was still live, and there was another lawyer, opposing lawyer, listening in to this lawyer-client communication. And he thought he was being very clever because he's taking notes about what the lawyer's talking to the client about. And then in a motion filed 2 weeks later, he has detailed notes to support his motion. Learn what he learned during that surreptitious eavesdropping of the Zoom call. Well, my client calls me and like, is this appropriate? Then my partner and I did some research on it, and it was very clear. There are a couple of cases where this has happened, not so much with Zoom, but otherwise. And the cases are all uniform on it. This is wrong. You cannot do this because it is conduct prejudicial to the administration of justice in violation of Rule 8.4. And that's kind of the catch-all rule. And it's deceitful, involves deceit, really, and it's wrong. Well, so we call the other lawyer out on it. The other lawyer says, no, this is your fault. Your client should have taken reasonable measures to make sure that this was a confidential communication. Well, true, and I do think my client bears a little of some responsibility here, because we all should be careful about these sorts of things. So what my client did was somewhat culpable. But what the other lawyer did was clearly wrong. And that other lawyer knew, or certainly should have known, that this was inappropriate conduct. So I don't know what's going to happen to that other lawyer. There's a disciplinary complaint heading against him. And it'll be interesting to see how it goes through the process. I mean, I'm not involved in it anymore, but I think what the lawyer did was wrong. I think what my lawyer did was a little wrong, but we all ought to be more careful about that sort of thing. You know, this is something that it's not really new, but it came up a couple of times recently for me, so I just stuck the old slide back in there. And that is, what about that fixed fee agreement that's gone bad? I don't do a lot of fixed fees with my disciplinary clients, but whenever I do, I lose badly. And you know, some lawyers have tales of taking that good fixed fee and then not doing a lot of work and closing the file, and everybody's happy. But this ethics opinion addresses the fixed fee agreement gone really bad. That is, you agree to do something and then all sorts of unexpected events happen. And the next thing you know, you want to go back to the client and say, hey, I know I agreed to do this for $5,000, but you know, now I've got to go to the World Court at The Hague for you, and here we are. None of us expected that. Is it okay for the lawyer to do that? Well, you know, the starting point is, well, a fixed fee is an allocation of risk between the lawyer and the client, where the lawyer undertakes the risk that this is going to take longer than the lawyer expected. That's just the way that risks are allocated in a fixed fee agreement. However, the ABA reasonably said, look, you just have to look at a request to modify the fixed fee agreement as you would look at any fee agreement. It's got to be reasonable under 1.5a. So is it ever reasonable to go back to a client and renegotiate a fixed fee? And the ABA opinion is yes, under extraordinary circumstances. When something happens that nobody would have anticipated, it's okay to go back and renegotiate it. But if it's just taken a little longer than you expected, or you've got to do more than you had hoped, that's not enough. It's got to be truly extraordinary, and something that could not have been reasonably anticipated by either party. And I think that is a good opinion. I don't know why my partner leaves the slide in there. You don't need malpractice insurance in Louisiana. You should have it, but you don't need it. So, you know, interestingly enough, some states, no state requires malpractice insurance, though several require reporting to the bar whether you have malpractice insurance. We talked about that in Louisiana, but we decided not to recommend it to the Supreme Court out of the fear that if clients could go on the website and see that you had malpractice insurance, they might be more likely to sue you for malpractice. I don't know whether that's true or not, but that's. This is a formal opinion that came out late last year about what do you do when you come to suspect that your client's involved in some criminal or fraudulent activity. And this came up recently in my practice. I don't know how many of you are practicing around here, but in New Orleans, there's been a whole bunch of cases involving car wrecks on I-10 where the allegation is that lawyers are involved with staging truck accidents. And of course, a lawyer, if you're a personal injury lawyer, you want to sue a trucking company because they've got millions of dollars worth of coverage, while your average New Orleans driver has $15,000 worth of coverage. So you love cases against truck drivers and their employers. But the problem is that people living in the city know that, and they have been staging accidents, which is they'll go out on the I-10 and they'll get right next to the truck, run into the truck, and have their friends behind say that the truck ran into them. And of course, everybody comes out holding their necks, and they bring a personal injury case. Well, about 30 people have pled guilty, being involved in, they weren't coordinated together, but they were all doing the same thing. And about 30 people have already pled guilty, including one lawyer. And a couple of other lawyers are under investigation. And these are, two of them are my clients. So one of the issues is, what is a lawyer's obligation when she thinks that her client may have staged the accident, but she doesn't know? Now, the mens rea, the mental element, the culpability for this disciplinary violation, of course, is knowing. You violate the rules only if you knowingly assist a client in conduct that is criminal or fraudulent. Knowingly. So if you just suspect, that's not enough. But this opinion, which came out last year, and again, timely for me and my clients in this area, really kind of adopts the ostrich instruction that federal courts have been using for years in drug possession cases, which is, suppose you're driving a car over the border and you go, "Oh, I didn't know there were bales of marijuana in the truck. I never looked in the trunk. I just never looked back there. Some guy loaded some stuff in there, but I couldn't see what it was." Well, the ostrich instruction is that if there is some substantial probability that that's drugs, you have a duty to inquire further. You can't just stick your head in the sand and say, "I don't know what's in those big boxes. I don't know what's in there," and drive across the border. Well, now that's kind of the same thing the ABA says for lawyers. If you have a strong suspicion that your client's engaged in fraudulent criminal activity, you have to inquire further. So you can't just say, "I don't have the requisite knowledge required as the mental element of that disciplinary offense." If you stick your head in the sand, that's enough to constitute knowledge under those circumstances. And so my advice to all these clients with the truck accident cases is, if you strongly suspect your client staged this accident, run. Because not only will you have a disciplinary problem, but you're going to have a criminal problem. Yeah.
Question, just a little granular on that too, but what are the sentencing guidelines on that? Because that's a real public safety issue. Somebody staging accidents, it could go awry. Obviously, it's become a lot.
Yeah. Well, I'm pleased to say I don't know, because nobody's gotten to that stage with me so far. But I don't know. I never thought about the public safety aspect. Generally, those guidelines are going to be computed under the fraud guidelines, so it's all just the amount of loss. And of course, it's not just the loss for your client, the defendant, it's the relevant conduct, which includes the whole scheme, all the loss associated with the scheme. So you get responsibility for all your co-conspirators' fraudulent activity. But I bet there is an enhancement, some specific offense characteristic that bumps up, gets you extra points because of the public safety. I never thought about it. Yes.
So on that, so you ask a client whether, they're being deceitful or not. The client said, "Well, no, I'm not being deceitful." Then they're off the hook. Or do you have to dig deeper than that?
Yeah, that's when you pull out this opinion and you start looking carefully at it. I mean, of course, the client's going to tell you, I'm not defrauding anybody, but you just have to look at all of the evidence and see whether or not there is a substantial likelihood.
Yeah.
You know, it's not just maybe, it's just maybe, then that's not going to be enough to be knowledge. It wouldn't be fair to say that you, the lawyer, have knowledge of fraudulent activity. It's got to be more than that. But I mean, there's always been this difficult tension in these, with this ostrich instruction, because the mens rea in all these possession offenses is knowledge, not negligence. You can't get convicted of one of those crimes through negligence. Then it would turn a crime that requires knowledge into a crime of negligence, and that's not fair. So it's got to be something greater than negligence, but something less than knowledge, actual subjective knowledge, which is it's a tough line to walk, and it's kind of a fun issue when I teach criminal law to talk about that issue. But
What about willful blindness?
well, that's the same thing. The ostrich instruction is willful blindness, and in those cases, the culpability is that you are intentionally, willfully avoiding knowledge that you suspect or probably know is going to give you actual knowledge. Yeah, so that's what the ostrich instruction is willful blindness. This is something that comes up in reported opinions every couple of months, and social media, lawyers using social media. Back a couple of years ago, people would always say, hey, would you do a speech on lawyers, social media use, et cetera, and I would do that every now and again. But social media doesn't present any new ethics issues for lawyers. I mean, every time a new technology comes out, everybody thinks, oh, there are new ethics issues. What about these cell phones? Can I talk to my client on these cell phones? Can I use faxes? Can I use email? Must I encrypt the email? Those sorts of things. Well, when social media started becoming very prevalent, people wanted to say, what ethics issues does that present for lawyers? Well, no new ones really, but social media has led to lots of discipline because it just gives, well, two reasons. It gives lawyers a grander stage on which to play the fool, and nothing ever goes away. If you do it on social media, you think you have deleted that post from Facebook, but it's still there. And the subpoena can get it to the disciplinary authorities. So what about negative online reviews? You can imagine the situation, and somebody just goes on to Google or Yelp, or I guess those would be the two big, or Avo or Martindale.com, any of those, and then posts a bad review of a lawyer. Well, what several lawyers have done is that they have, and here's a recent one from Tennessee this year, where this lawyer responded to a negative online review by essentially saying, yeah, I know my client wasn't happy, but my client lied in her deposition. I forget exactly what he said, but it's the same story in all these cases. The lawyers are defending themselves by disclosing confidential information about their clients. And it seems so obvious that you can't do that, but lawyers do it. And that's the nice thing about this ABA opinion from this year. They just say, look, don't do that. Don't disclose confidential information. And when I get the question, I always tell my clients, hey, look, I know you're pissed, but what you need to do is just go online and say, I would like to respond to this, but my professional obligations prohibit me from doing so, period. Well, then it lets the world know that there's more to the story, but it also shows that you're not going to get sucked into some social media squabble. And that's kind of a respectful and dignified way to show the world that you didn't do anything wrong. And basically, that's what the ABA advises in this opinion is to don't do that. This is something that came up in my practice in New Orleans, and the client's name is Morris Bard. He's he's the biggest probably TV advertiser, billboard advertiser in Louisiana, and he gets lots of work. Now, I say I avert my eyes from these billboards, but I saw recently on his billboards that he doesn't even put his telephone number on there anymore. Why does he not put his telephone number on there? Well, because people can't remember telephone numbers when they're driving. What do people do when they want a lawyer? Well, they get on their phones mostly go to Google and then they Google the lawyer they're looking for. So what Morris Bart gets most of his work from people on mobile phones, Googling the name Morris Bart. And then they find his website and they go to him, they call him, and he works the case. So that's the way lawyers get cases. So what is this? What lawyers started doing to Morris Bart, and lawyers are doing this all over the country, is that they will buy the name Morris Bart as a Google AdWord. And so that way, when somebody Googles Morris Bart, who pops up first? Not Morris Bart, but the lawyer who bought the name Morris Bart. And you can see it's a fairly straightforward advertising scheme. The first time I ever saw this, at least reported, was in, I think it was South Carolina, where a lawyer had done this, and they brought disciplinary charges against him. This was his defense. His defense was, yeah, that ad word is for the biggest advertiser in South Carolina, but I wasn't thinking about that when I bought the name. Google recommended it as a good name to get cases, so that's why I bought it. And the hearing committee, they just all kind of recoiled and they said, well, you've lied to us now. And they suspended the guy mostly for lying about why he bought the name of the competitor lawyer. So back to the question, is this appropriate? Well, some have argued that this is a false or misleading advertising product scheme. Some have argued that this is kind of misleading under 8.4, and therefore it should subject the lawyers who are doing this to discipline. And I get that. I mean, to the extent that and this is what somebody was doing to Morris Bart. When the person would call, the guy answering the phone, it was an answering service, would say, "Hello, this is your lawyer." And the person would say, "Is this Morris Bart? This is your lawyer. Can we help you? Tell us about your." They just start talking really fast. And they would never say, "Oh, no, this isn't Morris Bart." But they wouldn't outright lie and say, "Oh, no, you haven't reached Morris Bart." They would say, "We're your lawyer." And of course, they recorded all of this. So that clearly, to me, is false or misleading. Clearly, it's false or misleading. But contrast that with what another lawyer in New Orleans is doing. And here's the kind of, so that's kind of advertisement A. Thanks for searching for us. You found your personal injury lawyer. Click here for a free consultation. The whole point of that is to deceive the person into thinking that they've gotten Morris Bart, right? I mean, that's the whole point. The point is to deceive. But there's another lawyer in New Orleans who's doing something similar to this, where she's saying, it's not a she, it's a he in New Orleans, but he says he's bought Morris Bart's name. And then when you get, what pops up is, looking for Morris Bart, question mark? I'll do your case cheaper. So he's doing the cases for 20%, 25%, rather than the 33%, 40% that Morris Bart would do. That to me is not a problem. Although, some people say, no, it's still false or misleading. You're buying some other lawyer's name. But, under the Lanham Act, the whole problem with false or deceptive advertising is you're misrepresenting the origin of goods or services. Here, you're doing just the opposite. You're saying, I am not Morris Bart. Come to me. So that to me, and again, some of my clients who advertise and get their names bought don't like my view on this, but I think that as long as you're doing it that way, when you're buying the name to distinguish yourself, there's no Lanham Act problem. There's no, probably, there is something that bothers me and everybody about buying some other guy's name, but it's not as egregious as.
So it's transparent.
Yeah, it's all, exactly. You're not saying that this is your lawyer trying to deceive.
That's not different than buying a billboard on his building.
Yeah, and which you could always do, right?
I mean, that's
Right, the real problem is, I mean, imagine if, trying to analogize it to a kind of a physical advertisement, if you put up a sign that said, Morris Bart's office this way, and you turned in there, and the next thing you know, you're in Gordon McKernan's office or something, some other lawyer's office. Well, I thought I was going to Morris Bart. Here I am in another, well, I'm here, I might as well just go. The lawyers who do this are trying to do.
Yeah, I agree with that one.
That's right.
I don't see how this can be a problem.
Yeah, I don't see it as a problem either. But you know, the thing that really struck me most about this is how creative lawyers can be. Yeah, who would have thought of it? Who would have thought of it? But now it's not an uncommon practice. This is something that came out in an ABA formal opinion this year, but in 2020, right after the pandemic, I was getting a number of calls about this, and this is the issue. Suppose it's the pandemic, you don't have to go to your office, so you want to come down to New Orleans and hang out rather than sit in New York City where everything's shut down. And this is, we got two clients doing this. Question: am I engaged in the unauthorized practice of law in Louisiana because I have moved myself down to New Orleans and set up in my extra bedroom in the Bywater to practice law? Now I'm only practicing law through my New York firm on New York cases for New York clients on matters controlled by New York law. What difference does it make, say the lawyers, that I'm in Louisiana? Well, the problem is, under the existing UPL law, that you are continuously and systematically practicing law in Louisiana. It doesn't matter that you're practicing New York law. You're in Louisiana, territorially practicing law. And that is UPL. And it just is. So, and that's always been my advice to these clients. Now, most of them say, oh, well, that's too bad, I'm gonna keep doing it. Okay, well, that's fine. You'll probably never get caught. So I get it, I'd probably keep doing it too. But the ABA, and again, I don't know what import this ABA opinion is really going to have, because in Louisiana, as in many other states, the unauthorized practice of law is a felony. I mean, if you get charged by a DA with a felony for unauthorized practice of law, I can't imagine you could say, well, the ABA says to do it. So
That seems completely out of step to me when you think of what the pandemic, the way it changed everybody's way of working. And to me, again, if you're still practicing in New York State and you're only working on those cases, it shouldn't matter where you are physically.
I 100% agree. But that's the difference between should and is, what the law should be and what the law is. And the ABA, as much as I agree with it, was the ABA said, is that the ABA says it's fine. And I think it, as a normative matter, should be fine. But as a descriptive matter, I'm not sure it is fine. So I like the ABA's thinking on this. I like their approach. It's perfectly reasonable. To do otherwise is stupid. But so in any event, I think this is, and there have been cases on this. One of my kind of favorite cases on this is some guy lives in Minnesota and his wife is from Colorado, and her parents get into a fight with a condo association back in Denver. So she says, "Oh, honey, would you help my parents?" So of course he writes nasty letters to the condo association. They go back and forth. They settle the matter, and then the lawyer for the condo association in Denver turns him into the Colorado authorities for unauthorized practice of law in Colorado. Of course, he didn't get paid anything. All he did was write some letters, didn't go to court or anything. And what happened? He got publicly reprimanded for the unauthorized practice of law. Now that's different from this hypothetical because, of course, he really is practicing Colorado law for Colorado plaintiffs against Colorado defendants. So that's more understandable. But it's always baffled me about the UPL laws, and we license lawyers, of course, at the state level, and we put up barriers to lawyers crossing state lines. It's easier in the EU to go from Belgium to Italy to practice than it is to go from Louisiana to Mississippi, which again just shows you how parochial law practice regulation is. But that's where we remain. This is something that came up in an LSBA advisory opinion in 2019, but the ABA is working on an opinion right now. This is one that's under advisement. You get an email from your opponent, and your opposing counsel CCs her own client. I mean, we all CC our clients when we're, I CC my clients on everything, but I usually BCC my clients just because I just do, I BCC my clients on everything. This lawyer CC'd the client. So when the receiving lawyer gets the email from his opponent, he writes back, he hits reply to all and writes back and says, whatever he wants to say. Well, then the client, the other lawyer's client, gets that CC, the reply to all, right? Then the other lawyer turns him in for violating Rule 4.2, which says you cannot communicate with a represented person unless you get the authority of the person's lawyer. So the question is that a 4.2 violation? And this opinion essentially, and we'll see what the ABA says on it, have said that, yeah, you can't do that. That's 4.2. You've got to make a point to delete the client, your opponent, the opposing client, from your email. It's not an implied authorization by the other lawyer to communicate just because the other lawyer is CC'd rather than BCC'd the client. Now, I'm kind of belaboring the point, but I kind of feel otherwise. It seems to me that once the other lawyer put the client in the CC, then it's fair game. It's fair game. But I don't know what the ABA can say on it, but the kind of prevailing view is no, you can't do that. That's another reason why you probably should not CC your clients. You should always BCC your clients to avoid the reply to all problem. Yeah.
I have a similar, I guess, related thing on communicating with representative, maybe represented people. We had a dispute in our office this week. What are ethically, are you permitted, say a personal injury case, are you permitted to speak with a treating physician or a treating physician's assistant or something? They're not a retained expert, and maybe they're not even a current treater. It's a former.
I've had that twice in disciplinary cases in Louisiana, where lawyers have communicated with a treating physician. Now, both of those cases, they would resolve through negotiated consent discipline, but there was a problem because the doctor didn't have a HIPAA waiver, and the doctor never should have talked about it with the lawyer. So the problem for the lawyer was the lawyer knew or should have known that the doctor couldn't talk to him without a HIPAA waiver. You see, so that was really a kind of a HIPAA problem. The lawyer was getting information from in an improper way. So that was the problem from the lawyer. It's not a 4.2 issue. It's kind of sounds similar, but that is a problem. I think it's okay as long as there's a HIPAA waiver. So, or the lawyer just takes the deposition of the treating physician, and everybody's there, and there are no problems. But just picking up the phone and calling that doctor does present that HIPAA issue.
But why would it be on the attorney to know not to have that communication without a HIPAA waiver in place, as opposed to the doctor knowing it shouldn't be disclosed?
Yeah, that's kind of, it's his fault, not mine, and there's some truth to that. But the lawyers, I think everybody knows about HIPAA. That's not something that, particularly a lawyer who does personal injury work and is constantly getting signing HIPAA waivers every week.
Well, but if anybody knows about how HIPAA works, it's the doctor.
Yeah, I'm with you. I want you on my hearing committee if I'm representing one of these clients. I do want you, but I agree. And that's the argument you'd make for the lawyer. But I can see the other side.
HIPAA doesn't apply to lawyers unless your client is a doctor or hospital and you're getting records directly from them.
Okay, I'll see.
So
Say that again.
go ahead and talk to whatever doctor you
lawyer-
want to talk to.
Except in Louisiana, there's a statute. that
That's
says
state.
You cannot talk to.
That's a state law,
That
but
is a
not
state
HIPAA.
law.
Yeah.
So, but you cannot talk to the doctor. Louisiana state law.
Yeah, well.
But a
I mean,
federal law doesn't.
so,
Even,
I mean,
even if you have a HIPAA release,
Yeah.
even if you
If-
have a release
Really?
or a record, you
Right.
cannot talk. to
Has,
them.
you
Now,
have to
when I
have,
started practicing law, you could. If you had a release, you could talk to a doctor. That's not the case.
Right.
Yeah, I mean,
and your HIPAA is supposed to, if you get an authorization, the doctor is supposed to have it specifically authorized oral communication, separate from
right.
records.
Yeah, and again, I forget the exact, because I'm no expert in HIPAA or on,
But if you're an attorney for a healthcare provider and you get a record from your client, you're now covered by HIPAA. So you can't disclose that record without an authorization that it complies with HIPAA.
yeah, interesting. See, I don't know about any of this stuff.
And if you go to a federal hospital like the VA and stuff like that, it's even more difficult.
Yeah,
It's really difficult to get records from the VA.
but the lawyer, so for all those reasons, the lawyer shouldn't have picked up the phone and called the treating physician. And that was the problem. Whether it was HIPAA or state law or whatever, I forget those details, but I knew that it was a confidential communication. The doctor's confidentiality was a problem. Couple of cases. This is one that is going on that just came out of the Fifth Circuit in July. And full disclosure, I'm one of the plaintiff's lawyers in this case. So this is a case that I love, but this is the case. I represent Randy Boudreaux, who's a lawyer in New Orleans, and he has sued the Bar Association because it is a mandatory bar association. Sued not only the Bar Association, but the Supreme Court for forcing Louisiana lawyers to join the state bar for the privilege of having an occupational license to work. So, two-part challenge. One is the broad associational concern. Of course, the First Amendment says you have a right to freedom of association. And the corollary is you have a right not to associate with a group if your government is trying to force you to do it. The argument is that all we want is an occupational license to work. Why do I have to join this organization in order to get that occupational license? It violates the First Amendment. That's the big associational challenge. We knew we were going to lose that because there are two U.S. Supreme Court cases that have said that it's okay. It doesn't violate that. But the thinking is that since there have been changes in the law governing public unions, that the Supreme Court's going to reverse that existing precedent. And so that part of the case is hopeless until the U.S. Supreme Court does something. But the smaller part of the case is that the Louisiana State Bar Association takes our dues money and uses it to engage in speech that's not germane to the practice of law. For example, over the last 10 years, the Bar Association has taken our dues money and lobbied paid lobbyists to lobby for legislation that has nothing to do with the practice of law on issues like gun control, taking positions in favor of gun control measures, taking positions in favor of certain types of curriculum being taught in Louisiana high schools, taking positions on LGBTQ rights. Again, I'm a big fan of LGBTQ rights. I'm all in favor of it. But the problem is that the bar has got nothing to do with the practice of law. It's a general social issue. The death penalty. I hate the death penalty, but the Bar Association lobbies against the death penalty with my dues money and my client's dues money. So what did the Fifth Circuit hold in July? They held in our case and in the companion Texas case that it does violate the First Amendment to force lawyers to be members of the State Bar Association when the State Bar Association is engaged in any non-germane speech. So we won. And on the kind of the smaller issue. So immediately, well, within a couple of weeks, the Supreme Court and the Bar Association changed all their policies and said, we're not going to do any more lobbying. We're disbanding the lobbying committee. We're not going to engage in any non-germane speech. So when we filed our preliminary injunction motion before Judge Adver in federal court here in New Orleans, saying, okay, the circuit says they can't do this, and joined the Supreme Court from forcing us to be members of this Bar Association. Their response is, well, we don't do it anymore. So their case is moot, Judge Adver, throw it out, it's moot. They don't do it, we don't do it anymore. They don't do it anymore because of the lawsuit, obviously, but we don't do it. But the problem is, and this is why, sometimes it could be so fun. After the Bar Association, after the opinion from the Fifth Circuit, and after we filed the preliminary injunction motion, the Bar Association Twitter account still every week comes out with non-germane speech. They've told, since we filed our preliminary injunction motion, they've told us that we should eat walnuts, that we should eat blueberries, that we should exercise, that we should go to church at the Catholic Church to go to the Red Mass, that we should this was last week, that we should be Secret Santas for poor kids. So, I had to file an affidavit last week in support of our preliminary injunction and it said, I like children and I like Christmas, but I don't like my bar association taking dues money and telling me to be a Secret Santa for a poor child. Non-germane to the practice of law. So I don't know what Judge Adver is going to do with this. Sure seems to me that it's not moot because they're still engaged in non-germane speech with our dues money, but we'll see.
Aren't you endangering by this lawsuit, the legislature coming in and controlling the practice of law?
Well, but they can't control it in a way that violates the First Amendment. And the Supreme Court, the Louisiana Supreme Court would never let them do it. There's a seminal case that's cited in all the professional responsibility case books across the country about how state Supreme Courts have the essentially almost exclusive authority to regulate lawyers. So if the legislature were to come in and start regulating lawyers, the Louisiana Supreme Court would say, hey, no, separation of powers problem, that's our problems. So yeah, I'm not worried about that.
Let me ask you, the Secret Santa thing, isn't it more of a voluntary program and?
It is,
not-
nobody's
it's not
forcing you.
mandatory, it's more voluntary.
It is. The problem though is it's non-germane to the practice of law. And if they're going to force us to join the Bar Association can engage in speech. And this is what the First Amendment says. It's not,
I understand your position there.
it's
but
the Fifth Circuit's
at-
position. It's not mine.
Right. At the same time, I think that when you have something where it's benefit, and listen, firms do it all the time, and that's their right to do that
And they
or not to do that.
can, right.
But I understand, lawyers do have a reputation thanks to all the commercials that are out there. And so isn't it a benefit to all lawyers if they have some kind of voluntary program to improve the image of lawyers through the Bar Association?
And that's fine as long as it's dealing with things like providing pro bono services.
And which they do.
And that's all germane to the practice of law.
And
So,
then maybe that should be expressed more than
Yeah.
their Secret Santa. But
yeah,
listen, I pay the dues just like you do too.
yeah.
And I don't, I also do the Secret Santa stuff, not with the Bar Association, but through our own firm.
Yeah,
And so I understand the argument there, but at the same time, also, when there's things that may be more voluntary as opposed to, again, the lobbying issue, that you're right, absolutely on that. They should not be lobbying on behalf of the Bar
Right.
Association for issues that not all lawyers agree on. That should not be something, if it's something involving tort reform, if it's something that's
exactly. That's all
involving,
fine. Well, tort reform's not okay. I mean, because
procedures in the court, I understand that, but
Right.
if it's something about whether or not what should be taught in the schools, things like that, I agree with you. That's not a purview of our Bar Association.
yeah, and it's a fairly bright line. I mean, if it's some issue that applies broad, it's good for lawyers because it's good for everyone, like walnuts, exercise, that's non-germane to the practice of law. Being nice to poor children, that's good for everyone. Going to church, now what about that? What about the Bar Association saying, everybody
Well,
show up at the Catholic Church?
Red Mass is usually, that's a tradition for, and because we are predominant, or at one time was a predominant Catholic state, that was something that I'm not Catholic, so I don't go to the Red Mass. But if the state bar association is sponsoring.
They're not sponsoring it, they're just engaged in speech.
And
About it.
listen, I see it too. I see the New Orleans Bar Association does it.
They can do, New Orleans Bar Association, they can do it all they want. It's not, because it's not mandatory. I mean, we're not forced to be members.
That's true.
Yeah, so fine, I don't have any problem with that.
But
If
a
there's
lot
a
of
Christian, I mean, the St. Thomas More, and the Catholic Lawyers
That's
Association,
right.
they sponsor it, man, I'm all for it. That's great. That's a great thing.
They
for
do.
St. Thomas More.
But I don't see any problem with having bar association announce it as much, because it's just an announcement. It's not telling you to go to it. But at the same time, there are a lot of organizations that announce it already.
Yeah.
I mean, there are good arguments either way.
Yeah,
I just don't see it as being as harmful. They're not telling you to go to church. They're just saying Red Mass is on this day.
right. Yeah, well, I hope Judge Adver disagrees with you, John. We'll see.
We'll see. He's got
We'll
Peaches
see.
2 out,
We'll
well,
see.
watching Peaches 2 out there. So.
Yeah.
And two thoughts. One, California, is always at the vanguard. And California has in its regulation of lawyers, and CLE requirement, these things about wellness.
Uh-huh.
And there's requirements that lawyers do things and continue to learn about their own wellness. So eat walnuts could fall into something like that. The other thing that's less silly is the tension, if you will, between the Supreme Court, the separation of powers. California, the state bar,
But they bifurcated the state bar, right? There's
they
a,
bifurcated the bar association.
right.
But the state bar itself is run by its trustees. More are appointed by government and legislature than by lawyers.
Right, but California is different from Louisiana because it's got part mandatory and part voluntary.
That's what they've done.
Yeah. So it's a different scenario. Here we're all mandatory, so that's the problem. But we'll see what happens.
So how do you foresee this playing out? Does the LSBA fall apart, or does it just change so it's not doing the things that your lawsuit says they can't do?
Well, they've changed, but they're still engaged in non-germane speech.
I heard you say that. What I'm saying is, do you anticipate that ends and the LSBA continues to exist and everyone's a member, or the LSBA falls apart, doesn't exist, and now we just pay
But I think-
license fees to be lawyers?
I think they're finally going to stop eventually all of the non-germane speech, including walnuts in church.
And then they're done,
And
and then
then-
the LSBA continues to exist.
Yes.
And then what is its role?
It'll keep doing all the same things it's doing right now, which
Which don't involve speech. Tell me what that is.
Oh, they do.
I mean, come on.
Well, they give each other awards in Sandestin.
Right? You go to the.
You've done a great job.
school.
You've done a great job.
Right?
Right. So they do a lot of that. I don't know. I'm not the right person to ask this question because I don't really, I'm down on the, I used to be on all the LSBA committees and I used to do CLEs just like this, probably 10 a year for the LSBA. Once I sued them, they kicked me off all their committees. I mean, they make me pay dues, but I can't serve on their committees and I can't speak at their CLEs because they don't like what I'm doing. If anybody should understand that it's okay for a lawyer to represent somebody you don't like, it should be a bar association. But they had threw a little tantrum about it all, and I can't go to their things anymore.
Does this surprise you?
No. It's fine, because I do enough CLAs, and I'm tired of doing them all anyway. So it doesn't. I found it amusing. I was getting ready to file a First Amendment suit against them because I got to be a member of this organization, but because of my views and my clients' views, I can't play. I mean, but I didn't bother. Would be fun though. Now I'm thinking about doing it. All right. Well, we don't want to do too many hours of ethics. We've already gone a minute over. Thank you very much for listening. I appreciate it.